back to winning isn't easy. Federal court rules that the claims process for a policyholder with fibromyalgia, multiple arthralgias, and small fiber neuropathy should not be a guessing game for a disabled policyholder whose policy has a non-verifiable impairment payment limitation of 24 months. That's a mouthful, but it's important because there are terms in disability policies or plans that will limit the payment of benefits. And this is really crucial, that you understand what benefits are available, what you have to prove to get those benefits, how long the benefits are payable before they stop work and apply for benefits. And if the claim's been denied, what it is you need to do to prove that that claim denial was inappropriate and wrong. So let's start out with typical ERISA policy or plan terms. Now, often a policy or plan will require proof that an injury or sickness prevents you from performing the material and substantial duties of your own occupation. After 24 months, the definition of disability changes from an inability to do your own occupation to an inability to do the material and substantial duties of any occupation that you become reasonably fitted by training, experience, education, physical and mental capacity. You've got to get your own policy or plan out to read this because this is crucial. You've got the burden to prove you meet this standard. Now, it's not uncommon for a policy or plan to have a 24-month limitation because of mental illness, substance abuse, subjective medical condition limitations, and non-verifiable symptoms. Any one of these can limit benefits to just 2 years. So what is the definition of subjective conditions or non-variable symptoms? It depends on what's in your policy or plan, because you may be limited to just 24 months. Now, one of the most common definitions of non-verifiable symptoms is a subjective complaint to a physician who cannot be diagnosed by using test procedures or clinical examinations typically accepted in the practice of medicine. Such symptoms may include, but are not limited to, disease, fatigue, headache, loss of energy, numbness, pain, ringing in the ears. So in other words, you're complaining, but there isn't necessarily a test or a procedure or a clinical examination that will document that, in fact, you're having dizziness or fatigue or headaches or a loss of energy or pain or ringing in the ears. So what does your policy or plan say? Let me tell you about Lincoln's plan denial of a claim and their use of the 24-month non-verifiable symptom limitation clause. Christina Conti worked as a senior radiation protection technician at Viola, North America. She became disabled because of extreme pain in multiple parts of her body, neuropathy, extreme muscle weakness, and loss of strength. Sounds like a non-verifiable symptom issue, doesn't it? She was covered under her employer's ERISA disability plan through Lincoln National Life. Conti consulted with and treated with specialists in neurosurgery, neurology, pulmonology, endocrinology, orthopedic surgery, radiology, and even cardiology. I don't think there was a doctor she missed. Of this group, only one provider restricted her from working consistently, citing her fibromyalgia as a likely cause of her symptoms and her physical limitations. She saw this physician regularly who supported her claim based on her pain, numbness, and fatigue. This doctor was a rheumatologist, and the rheumatologist found that the reports of pain and fatigue were out of proportion to the physical findings, but still thought she had fibromyalgia. Conti also underwent a test of her nerves by a neurologist to evaluate her leg pain, and that was suggestive of small fiber abnormalities. So we have some beginning of objective evidence. Over time, her physicians continued to note her reports of diffuse pain, but there weren't major physical findings, but they kind of backed into a diagnosis suggesting that her symptom complex was suggestive of fibromyalgia and small fiber neuropathy. And this is not uncommon in these types of cases. Now, Lincoln's engaged in some questionable claims handling practices. They paid short-term disability benefits and began payment of the long-term disability benefits. But then, of course, they had her file reviewed by their liar-for-hire peer review doctor, who opined, and this is the kind of language I see all the time, that objective clinical findings were insufficient to support a functional impairment that would adversely affect the claimant's ability to work. Gobbledygook for there aren't any restrictions and limitations, and now you've got a reason to deny the claim. which Lincoln did. And she filed a lawsuit. This case was called Conti versus Lincoln National Life out of Minnesota. The court concluded that it was more likely than not that Conti remained unable to perform her job in the months after her benefits were terminated. Now, the court addressed a number of factors in this case that I think are important and relevant to similar type cases. There was an alleged requirement that Conti supply continuous proof of an inability to work. And Lincoln's argument was rejected. And there was no such requirement that she continuously supply proof of her inability to work in the policy. This mattered because even if there had been, Lincoln never told her what proof of her physical limitations she had to supply and what she hadn't supplied. And they didn't even suggest that she undergo a functional capacity evaluation or a similar examination of her physical abilities, even though the plan authorized them to have such testing. So she was in the dark. And the bigger issue, of course, was the guessing game of proof. Lincoln impermissibly converted Conti's disability process into a guessing game, which was not reasonable under the circumstances and weighs against denying benefits. The court weighed the medical evidence and found that Conti's fibromyalgia, multiple arthralgias, and small fiber neuropathy, and her repeated and consistent report of symptoms and limitations were consistent with the nature of those conditions. And the rheumatologist's years-long acceptance of her reports of pain as precluding her ability to work made it more likely than not Conti remained unable to work, even though the rheumatologist was a little poo-pooey about the severity of the complaints. The rheumatologist consistently agreed that she was unable to work, and that was very important. The court noted that none of Conti's providers found her unbelievable, and none of them opined that there was any other reason that she couldn't work. So it was this continuity of treatment, continuity of complaints, and the support of a physician over time that impressed the court. The other thing that impressed the court, and was, by the way, criticized by Lincoln, was Conti's traveling to other states to seek medical care. And Lincoln said, hey, look, that's the equivalent of an ability to work. And oh, by the way, yes, she went camping, and they argued that that was an ability to work. The court said that, look, just because she goes camping or travels to see medical providers in other states doesn't mean that she could do this on a sustained level. The court also addressed the credibility of Conti's doctors and the failure of Lincoln's peer-reviewed doctors to appreciate the significance of normal examinations. I like this one. The court found Conti's treating physicians to be credible. They had diagnosed her with severe fibromyalgia in 2019 after she reported extensive pain, and she did present with tenderness in all 18 trigger points used to diagnose fibromyalgia. And so the court noted that there was a positive testing for fibromyalgia, but the court also noted that there were times when the examination was normal and unremarkable. And the court noted that the reviewing doctors failed to look at the totality of the evidence, the normal examinations, the unremarkable examinations, that eliminated kind of any other source of her pain and discomfort, but in fact reinforced the diagnosis of fibromyalgia. And of course, Lincoln's doctors never even considered fibromyalgia in their medical analysis. The court also considered the award of Social Security benefits and the previous payment of long-term disability benefits. The court found that the disability was supported by her award of Social Security benefits and the fact that Lincoln had paid benefits based on the information related to her fibromyalgia. And nothing had really changed over the years between Lincoln's payment of benefits and then their decision to terminate benefits. I have to tell you, though, the most frustrating part of this decision was, despite the acceptance of Conti's medical records, the diagnosis, and the criticism of Lincoln's analysis, the court remanded the case back to Lincoln to determine whether or not she qualified for benefits under the any occupation standard. She had been paid all of the 24 months of her own occupation, and then she hadn't been paid any occupation benefits. So the court sent it back for them to address those issues. And to that extent, I sort of get it. But the problem, I think, is that Lincoln's going to deny this claim a second time, and try to, again, invoke the 24-month policy limitation. I think there's a lot of great lessons in this case, and these are the kinds of strategies that ERISA attorneys such as myself will employ as we take apart these peer review reports that are used to justify claims denial or terminations. You can see it's all about strategy. It's all about the quality and quantity of your medical records. It's all about you giving a really great interval history of your symptoms and functionality. I hope that you have enjoyed this episode. Please like our page, leave a review, share it with your family or friends. Please subscribe to this podcast. I hope you tune in next week for another insightful episode of Winning Isn't Easy.